Hello everyone, thank you for taking the time to listen to my presentation. Today I will be exploring the controversial news story of the Trans Mountain Pipeline Expansion project. As seen through the picture on the left, the Trans Mountain Pipeline is a pipeline owned by the Canadian federal government that carries oil through Edmonton, Alberta, and BC. Just to give everyone some context of the presentation, I will run you through today's agenda of the topics that will be covered. To start, I will describe the overview of this case, which is essentially that the Federal Court of Appeal is to decide if the government adequately consulted Indigenous communities before approving the expansion project. Then I will move into discussing the non-consensus amongst the Indigenous nations due to the diversity amongst them. After discussing the non-consensus, I will set out the legal issues that this case raises in order to situate the issue in its legal context. Next, I will discuss the historical context by exploring the possible impact an expansion would have on the treaty rights. And once discussing the impact on treaty rights, I will move into the implications on reconciliation and colonialism. With regards to the overview of the facts, it is important to note that in 2018, when the federal government bought the Trans Mountain Pipeline for $4.5 billion from Kinder Morgan, the Federal Court of Appeal overturned the approval of the pipeline expansion because the National Energy Board's review of the proposal was flawed and the federal government failed in its duty to engage in meaningful consultations with Indigenous nations. However, with regards to the case I have chosen, this is regarding the federal government's second approval, which occurred in June 2019. Although the approval was overturned the first time, with one reason being that there was a lack of meaningful consultation with Indigenous nations, in September 2019, the Federal Court of Appeal agreed to hear the claims that there was inadequate consultation with Indigenous communities once again. As evident through the diverse set of Indigenous nations that inhabit Canada, it is not a surprise that due to differences in beliefs, traditions, and practices, some Indigenous peoples endorse the pipeline expansion while others oppose it. Shane Gottfriedson, BC Director of Project Reconciliation, believes that there is a pipeline to reconciliation and that Indigenous communities should take it as it is a step towards financial self-sufficiency. Project Reconciliation aims to allocate 80% of its pipeline profits to develop infrastructure and businesses in Indigenous communities. Also, Western Indigenous Pipeline Group are interested in purchasing 51% of ownership of the pipeline. This ownership could help Indigenous communities overcome socioeconomic barriers such as poor water systems, lack of employment, and poor infrastructure. By allocating these profits from the pipeline to addressing the socioeconomic barriers, these nations believe that this would be a step towards reconciliation as it would allow them to overcome the legacy of colonialism, which includes the loss of traditional lands and resources. On the other hand, there are Indigenous nations such as the Cold Water Indian Band, the Squamish Nation, the Upper Nicola Band, and the Tsleil-Waututh Nation who oppose the expansion. As we can see on the picture on the right, these nations all inhabit communities that are situated along the pipeline. Their primary concerns are that an oil spill may threaten the drinking water, coastal life, salmon population, and surrounding spiritual communities. It is important to consider, as noted by the Truth and Reconciliation Commission, failure to distinguish between the diverse people of North America is a resemblance of colonial behavior. If there was inadequate consultation in the process of approving the expansion of the pipeline, the potential legal issues that may be considered are the duty to consult, which was set out in the Haida Nation case, international standards, and the right to self-government. When considering the duty to consult, which was set out in the Haida Nation case, the court decided that if the Crown contains knowledge of any potential adverse consequences affecting Aboriginal rights, treaty rights, or title, the honor of the Crown requires the Crown to consult with Indigenous nations. It is important to note that it was also decided that even if the land has not been legally claimed by Indigenous nations, the government still has a duty to consult. Therefore, it is evident that the duty to consult protects the rights of Indigenous peoples. The duty to consult is also embedded in the principle of the honor of the Crown. The court stated that the principle of reconciliation is included in Section 35 of the Constitution Act 1982, and that the honor of the Crown would be meaningless if this duty did not exist. Therefore, if the federal government did not consult First Nations, this could be seen as a dishonoring of the Crown and lack of commitment to reconciliation. The second legal issue which would arise from the federal government's lack of meaningful consultation during the approval process of the pipeline expansion would be the implications when considering international legal standards. In 2016, the Canadian government fully endorsed the United Nations Declaration of the Rights of Indigenous Peoples. This is important because international standards that are included in declarations that Canada have endorsed are sometimes used for interpretation of domestic laws in cases of doubt. This declaration that Canada has fully endorsed includes articles such as Article 32, which states that states shall consult and cooperate in good faith with Indigenous peoples prior to any project affecting their lands in order to obtain their free and informed consent prior to the approval of any project affecting their land or territories and other resources. This form of consultation sets the standard higher than the duty to consult. Therefore, if the federal government did not adequately consult Indigenous communities, this may be viewed as inconsistencies between their words and actions, further hindering progress towards reconciliation. In the case of R.V. Pamajiwan, the Supreme Court confirmed that self-government is an Aboriginal right. It is important to note that self-government rights provides lawmaking authority pertaining to economic development and land. Therefore, inadequate consultation may have infringed on the rights of lawmaking authority pertaining to economic development. Also, self-government agreements enable Indigenous peoples to have input on decisions that directly affect them, which also means that if there was inadequate consultation, this may have resulted in not enabling Indigenous peoples to provide an appropriate level of input into the decision, therefore a possible infringement of this right. An issue that some Indigenous nations that are situated along the pipeline would want to raise through consultation would have been the effect the expansion would have on treaty rights. And we can think about this idea by using the Coldwater Indian Band's treaty with the Crown. An oil spill may impact the Indigenous peoples of the Coldwater Indian Band to exercise their treaty rights to hunt, gather plants, and trap. This idea is important because based on the Crown's fiduciary duty, although the Crown has sovereignty over Indigenous land, they must place the Indigenous people's interests ahead of the Crown's, and when interpreting Section 35 of the Constitution Act 1982, the Crown's fiduciary duty is considered. With regards to the lack of consultation in colonialism, one may raise the question that if there was inadequate consultation, is the Crown hindering the negotiation and renewal stage of the relationship with Indigenous peoples? The purpose of this stage is to attempt to renew the relationship and work towards reconciliation with Indigenous peoples in Canada, and lack of consultation may be viewed as dishonoring this intention. The process that the Crown may have undertook could have been seen as an act of colonial behavior with the goal of exploiting Indigenous land for economic purposes. With regards to reconciliation, as mentioned earlier, some Indigenous nations view that the ownership of the Trans Mountain Pipeline is a step towards reconciliation. However, other nations believe that such an expansion is a step backward. The Canadian federal government faces the issue of balancing the interests between those that are for the pipeline and those that are against it. However, regardless of this issue, meaningful consultation is necessary when considering honoring the Crown, self-government, international standards, and treaty rights. The last question I will pose is that although a lack of consultation may hinder reconciliation, can the expansion of the pipeline actually be a step forward when considering addressing the socio-economic barriers credited to the legacy of colonialism? As of September 30th, 2019, Trans Mountain has provided 2,200 jobs with the focusing on employing Indigenous peoples. So once again, although consultation is necessary, can the expansion of this pipeline actually be seen as the federal government addressing and attempting to alleviate the socioeconomic barriers that Indigenous communities face? The key takeaways from this presentation are that firstly, there is a non-consensus regarding the approval or disapproval of the pipeline expansion amongst Indigenous nations due to the diversity of beliefs, practices, and traditions. Next, the legal issues that may arise if Canada did not adequately consult Indigenous peoples before approving the pipeline for a second time would be a dishonoring of the Crown, failing to adhere to the Crown's fiduciary duties, failing to recognize the right to self-government, and failing to adhere to the international standards set out in the United Nations Declaration of the Rights of Indigenous Peoples, which Canada has endorsed. With regards to treaty rights, if there was a lack of consultation, one may ask if this can be seen as Canada putting their interests before the interests of Indigenous communities. Lastly, a lack of consultation may hinder recent attempts of reconciliation with Indigenous communities, as it may be seen as an act of colonialism with the goal of exploiting Indigenous economic resources and land. This concludes my presentation. I hope you enjoyed it, and I look forward to everyone's feedback and responses. Thank you.